Good afternoon, everyone. Welcome to our virtual webinar. We will give it just a few more minutes to let everyone join in, and then we'll get started. We do have a few people trickling in, so we'll give it just a couple more minutes. Okay, perfect. I think we're about ready to get started. Thank you everyone for joining our webinar today in this virtual space. Today, you will hear from our partners at Immigrant Legal Resource Centers and their attorneys. But before we get started, I just want to go over some housekeeping rules. This webinar will be recorded. The recording and the PowerPoint will be available after the webinar. There is closed captioning available in this webinar today. If you see on the bottom icon, the CC closed caption, go ahead and click on that and you can read live captions. And then there is also an icon for Q&A. We will be utilizing the Q&As today for the webinar. If you have any questions, go ahead and post it there and we will share links and resources throughout the webinar as well. I will go ahead and pass that on to our partners at ILRC.
Thank you so much, Cynthia. And thanks everybody for joining us today on this webinar. So diving in, what are we going to discuss today? We are going to discuss some of the steps that we can take now ahead of whatever may come in the fall and with the new administration. We want to talk about some evergreen things that we can all constantly be doing to protect ourselves and our families as immigrants. So really, we're going to be focusing on taking control, know your rights, and immigration relief strategies. Today, I'm joined by a few of my colleagues, actually. We have Veronica, who joined the ILRC in 2017. Veronica does a lot of work in the Central Valley, also in the Bay Area. She has expertise in DACA, also in a slew of immigration relief options. She provides a lot of technical assistance to folks in the Valley and also in the Bay Area, and also does some policy work. And I'm also joined today by Mio, who will be supporting in the chat. Mio comes to the ILRC with a lot of expertise in a slew of different immigration relief options. She's defended folks in court, in affirmative cases, and also has deep expertise in know your rights and policy work. So thank you so much to Vero and Mio for joining us today. And again, a special thanks to Cynthia and others for partnering with us on this webinar. Okay, so diving in. These are, I want to take a moment and just pause on the topics that we'll be discussing today, and also want to flag that I imagine that a lot of folks today will have questions about all sorts of topics. If you do have any questions about your individualized case situation, your case, your family member's case, we will be providing information to you all about how to get individualized case consults, and those types of questions should really be placed in a private setting where you can have an individualized consult with an attorney. However, if you have any general questions, then we're happy to answer those. And as we go through the presentation, feel free to use the Q&A function to submit any questions to us that you may have, and myself or Vero or Amia will be happy to answer them in the chat. So with that, let's talk about what we're going to be discussing today. So we're going to be starting off with how did we get here? We all know that the federal government has a variety of tools that they can use to identify, detain, and deport individuals. We're going to first give a quick history lesson on how it is that we got here. Then we're going to actually break down the steps as to how it is that the federal government is able to identify, detain, and arrest people. And then we're going to pause and talk about how to fight back, because we actually do have a lot of tools at our disposal to push back, both policy-wise and also in terms of our individual rights. And carrying on with that theme, Vero is then going to give us an overview of different immigration relief options. In other words, what different paths might people have to status that they might not even know about. And then we're also going to end the presentation with talking about immigration consults and how to get those. Okay, so let's go ahead and pause a little bit and talk about how it is that we got here. Obviously different administrations have been worse than others when it comes to pursuing immigration arrests and pursuing more deportations. But it's important to understand that there's a larger history, and that whatever administration we get in the fall or we've gotten in the past, they've all received keys to a very well-oiled deportation machine. And how is it that that deportation machine has been built? So the modern day deportation system has really had its biggest growth in the last 40 or so years. So I'm going to talk about just a few moments in the last 40 years that have basically resulted in where we are today. In 1986, we had the establishment of the Criminal Alien Program, CAP. That program is actually the one that's responsible for a lot of the cooperation we see between jails, prisons, and ICE today. It's very intentionally named this very menacing name, Criminal Alien Program, to basically try to justify some of the really bad behavior that we see on the ground by ICE. But this has morphed and looks a lot of different ways in different jails and prisons, but it's really kind of the biggest problem in terms of police-ICE collaboration that we have in California and a lot of other states. In 1988, mandatory detention became law. So you might all be familiar from TV that anybody who goes in the criminal system has the right to bail or bond, at least has the right to request it. That doesn't mean that they'll necessarily get it. People unfortunately get denied that stuff all the time when they should be home with their families, but everyone at least has the right to request it. We unfortunately don't have that same right in the immigration system, and that's because of this mandatory detention law that was established in 1988. So basically what that means is that when ICE arrests somebody, certain people will be ineligible to request a bond in front of ICE or in front of an immigration judge. So certain people will be required to be detained, to be incarcerated for the duration of their immigration proceedings. If you ever have any questions about whether this law applies to you or a family member, you should always talk to an attorney, because this stuff is super complex, and ICE will often assert that someone is subject to this when they're actually not, when there are actually arguments to fight against it. So it's important for us to know that, unfortunately, this law exists, and this is one of many really harsh laws that have been introduced against immigrants over the years. But in terms of how it affects your personal life or your family members, you should always talk to an attorney, because there could be some discrete arguments we have to push back in terms of its application on individual cases. Before we move on, I also want to talk about 1996. This was actually a really seminal year in terms of some really terrible immigration laws that were passed. These were actually signed under Clinton. We had IRA, and EDPA. Those are the shorthand names of the laws. But basically, there was a pretty seismic shift in terms of immigration law. Mandatory detention was expanded. We saw the introduction of deportations without the ability to see a judge, and other laws that basically made it easier to deport people with fewer protections, fewer due process protections, a less ability to have a fair day in court. So we saw a lot of, this is probably actually in modern day history, the worst immigration law that was passed. And unfortunately, we continue to deal with it today. And then in 2002, the Department of Homeland Security was created. This was following the events during 9/11. The reaction by the US government was harsh. We also saw a reshifting of the way immigration is discussed, and it really became even more so an issue of national security and of securing our borders. That rhetoric wasn't new, but it really became much more harsh and much more reinforced after that event. And that's why we saw this massive restructuring and the creation of the Department of Homeland Security and an even bigger shift of resources and funding into that agency. Now, ICE arrests, it's not like ICE arrests were born on this day. There were ICE arrests happening under a different configuration of the government, but it is pretty significant. It's not every day that the government just creates new agencies and just reshifts things. That's actually a pretty big deal. And it really signals, again, a harsher approach and a more border enforcement approach to the way the federal government was looking at immigration law. Okay, now I was actually hoping that I'm gonna see if we're able to do this via the chat, but I'd love to ask y'all a question. Who do you think can be deported? And in front of you, you'll see a screen that has a lot of different types of immigration status. And so my question to you is, who can be deported from this chart? So I'll pause to see if it works out to do this via the chat. If not, maybe I'll ask my co-presenters what they think. But go ahead, and if you're able to, put it in that chat. Who from this list do you think can be deported? Okay, chat is disabled. Is what I'm seeing. So actually, Mio and Vero, can I ask y'all, what do you think in this chart? Who can be deported?
Well, seeing that it's a pyramid, I would go with the, that anybody below a US citizen could be deported, with the US citizen being on top.
That's right. Thank you, Vero. And so, yes, unfortunately, really anybody except for a US citizen is subject to deportation potentially. And so this is often a surprise to people because they think, oh, well, I have a green card. I should be okay, right? And unfortunately, all sorts of criminal offenses, even minor ones, sometimes being out of the country for too long, all sorts of often benign feeling things can actually trigger potential deportation proceedings. And it's the same for refugees and asylees, people who have DACA, people who are undocumented. So really the only people who are 100% for sure protected from deportation are US citizens. And this is any US citizen, people who were born here, people who naturalize like myself. Once you're a US citizen, you're good, you're gold. You cannot be subject to deportation proceedings. This is why we always push people to naturalize. And I know, people sometimes don't want to for whatever reason, but we always encourage people to naturalize because it's the one certain protection. However, one pause here is that if somebody has had contact with the criminal system in the past, they should definitely just pause and talk to an attorney before proceeding with their application, just to make sure it's safe, just to make sure they don't have anything problematic. Also, because if they do, oftentimes people are able to go back to criminal court and actually fix it so that they can proceed with their naturalization case. So we want everyone to naturalize, and if someone's had contact with the criminal system, just pause and get some advice from an immigration attorney so that you can proceed safely. Okay, and since I'm not sure if we're able to do this via the Q&A, I'm going to go ahead and maybe ask Vero or Mio about this. So where do ICE arrests happen? We know that ICE arrests can happen in different environments. So I don't know, Vero or Mio, if you guys have any ideas about what types of environments ICE arrests might happen in.
Well, I think they can happen in all sorts of places, but some common could be either after your criminal court hearing or in the street or even in your own home.
Yep, that's right. And so ICE arrests can happen in all sorts of different environments. So we hear about them happening certainly at the border, and that is a big place where they happen. They can also happen at airports, when people are applying for benefits. So when people are applying to naturalize, for example, if they do have a deportable offense, that could actually result in the person being handed over instead for deportation proceedings. That's why we want people to naturalize, but always pause and consult with an attorney if there are any potential issues. There are more rare, but it can happen, instances where the DMV provides information, but I do want to be very, very clear here that it's not like the DMV is just handing over everybody's information. There are actually privacy protections in California around that. It's only in very specific cases, and if you have questions about whether you or a family member should apply for a license, then just talk to an attorney, because it actually might make sense for people to proceed in a lot of cases. There are also ICE arrests that can happen in the home or in the workplace. We see these kind of fluctuate up and down depending on the administration. So this is something that kind of shifts depending on who's in the White House. But actually, the #1 way that we see ICE arrest people in the interior meaning not at the border, is really through contact with the criminal system. So I have this chart here that breaks down where arrests happen, and this is really focusing on arrests in the interior, so not arrests at the border. We tend to, when we look at data around ICE arrests, we tend to separate the two. So when it comes to arrests in the interior, we have the vast majority, as you can see, coming from arrests that happen from the state prison system, from jails, and from the criminal system generally. And Vero, Mio, if there are any relevant questions that pop up, feel free to interrupt me and I can just jump into them. But again, the majority of arrests that happen in the interior really happen because of cooperation that we have between criminal systems and federal immigration authorities. Okay, so how is it that ICE actually finds people? So in terms of how it is that ICE finds people in the criminal system, it's a variety of ways. So one of the big ways is by fingerprint sharing. So let's say that I am arrested by local sheriffs, local police, CHP, whomever, whatever state criminal agency here in California. If I'm arrested by them, then they will take me to a local jail. They will take my fingerprints, and this is regardless of immigration status. This is anybody. Those fingerprints are taken and they're shared with the FBI and they're shared with DHS, the Department of Homeland Security, the federal immigration agency. And so they're basically getting the fingerprints of everybody in the US at all times. And again, that's everybody regardless of immigration status. Now, if those fingerprints correspond with records that ICE already has about that individual, then they'll know, oh, okay, I know that, we have information about Grisel. We know that, maybe she has a prior deportation order. And so now we know that she's in LA County, and now we know where she is. And now we're going to see if we can work with LA County to arrest her. So basically, if they have a hit in the system on an individual, then they'll oftentimes seek to work with a local agency to actually arrest that individual. So that's one of the biggest ways. Another way is interviews in jails. So there are instances where ICE might not have enough information to arrest me quite yet. And so they want to go into the jail and actually ask me some additional questions to see if they can get what they need from me in order to put me in deportation proceedings. This is actually one of the first places where we have some really important rights at our disposal. So in California, I mean, this is actually a right that we have everywhere, the right to remain silent, but it is a right that we're informed of in California and may not be informed of in all states. So in California, prior to any ICE interview, the sheriff is required to pause and tell the person who's incarcerated, like me in this instance, they're required to tell me, hey, ICE is seeking to interview you. You have the right to decline to interview. If you want, you can proceed with an attorney, or if you want, you can proceed without an attorney. And we, of course, always tell people to decline the interview. There's really nothing good that can come of it. And so this is kind of one opportunity where our Know Your Rights advice comes in. Always assert your right to remain silent. Always decline that interview, whether you're encountering ICE in a jail, in the street, in a home, in a workplace. The advice is always going to be to assert your right to remain silent and not say anything. And then beyond that, there are other types of cooperation that can happen, that can result in ICE finding out about people getting what they need to initiate removal proceedings, things like database sharing, sharing of records, other types of information sharing. And then in terms of how, once ICE knows about an individual, in terms of how they actually arrest that person, again, it's because of cooperation from local law enforcement. So oftentimes the sheriff, because in California, most people who are incarcerated are in a county jail. There are some cities that have jails, but mostly it's counties. The local county jail, many in California, will voluntarily help ICE arrest a person. So if I'm being released from jail, instead of allowing me to, go be received by my family who's in the waiting area, they'll actually just transfer me to ICE in the back area. But one thing that's super important to know here is that cooperation is totally voluntary. So local county jails are deciding to cooperate with ICE when they don't have to. And that voluntary piece is actually super important because in a lot of counties, and we'll flag those in a couple of slides, in a lot of counties, they have actually, advocates have successfully convinced the local sheriff to not cooperate with ICE and not pass people over, and instead allow people to go home to be with their families.
Hey, Grisel. A question about ICE cooperation. So is that the same for someone who has had contact with ICE before and someone who never has had contact with ICE before?
That's a great question. Let's say I am going through the system, and let's say I am undocumented. So being undocumented, that in and of itself is enough for me to be placed in deportation proceedings. But let's say ICE has no idea that I'm undocumented. I've never had any contact with ICE. I've never been arrested by ICE. They have no idea that I exist. And so that's a great question, Vito. How would they even know that I'm deportable? And that is why knowing your rights and asserting your right to remain silent is so important. Because let's say I'm sitting in jail and ICE wants to interview me. Let's say they want to interview me and get from my own admissions the necessary information to put me in deportation proceedings. Usually what they're after is me admitting that I'm undocumented, that I was born in another country, that I don't have status here, and that could be enough to place me in deportation proceedings. So if I assert my right to remain silent, if I say no, I don't want to talk to ICE, and I always assert my right to remain silent in any other environment, ICE can't arrest me. They can't put me in deportation proceedings. That's actually a super important question, because if ICE doesn't know about me and I don't give them the information they need, then they actually can't arrest me. Okay, so what happens, really quickly, just want to talk about what happens once someone is arrested. So really quickly, after the ICE arrest, ICE will sometimes detain people sometimes by law, sometimes because they decide to, or sometimes will start the deportation process, but will allow people to be at home with their family while they fight their deportation case. If someone is detained, there could be an opportunity to request bond in front of an immigration judge, so to try to get out. Assuming someone doesn't have a prior deportation order, most people will have the opportunity to go in front of an immigration judge and fight their case. We do have a series of rights that apply here in immigration court. For example, you have the right to have an attorney. If you do have the right to have an attorney, but unfortunately, there aren't any public defenders in the system. So you have the right to an attorney so long as you're able to bring your own attorney, but we don't have public defenders. There's no right to government appointed counsel. You also have the right to have the hearings be in a language you understand. So if you don't speak English, then to have an interpreter. And then there are a few other rights that apply in front of the immigration judge. And then if someone loses their case in front of the judge, or if someone wins their case and the government appeals, then there are a series of courts where people can continue to appeal their case and continue to fight their case. But this, is just a shorthand view of generally the life of an immigration case, but every, different cases can be different. So this is just global, just a global overview. Okay, so now I'm going to talk a little bit about how we disrupt this pipeline and our rights and some state and local laws we have to protect us before I pass it on to Vero. Okay, so really quickly, we have, again, because this cooperation is voluntary, we have been successful in passing a series of laws to protect the community. And I do want to say that this is all a work in progress. There's actually a lot more that we could do in California, and a lot of folks, a lot of different organizations are going to continue to fight to try to pass stronger laws in the future. But in terms of some of the laws we currently have, we have the California Values Act, and that limits police-ICE collaboration in a series of ways. For example, law enforcement, any law enforcement, isn't allowed to ask about immigration status in California. So immigration status has nothing to do with any criminal offense. There's no criminal offense in California that has any element of immigration status. So they shouldn't be asking about immigration status to begin with. They have no reason to ask for it, so we just put that into law. Law enforcement in California also cannot use ICE as interpreters. And we did this because we saw that they were using interpreters in the field. And then obviously when DHS would come and act as an interpreter, they wouldn't just interpret, they would also try to get information and arrest the individual. So we put an end to that practice. And then it also places some limits on when law enforcement can help ICE with an arrest when a person is being released from jail. So unfortunately, it doesn't limit it in all cases, but there are some limitations. Basically, state law says in certain cases, they're not allowed to cooperate with those arrests. Then we also have the Truth Act, which is what I described earlier around the ICE interviews in local jails. Again, super important to know that prior to any ICE interview, the local sheriff or local jailer has to inform the individual of their right to decline the interview or proceed if they'd like to. And our advice, always, 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 whether you're encountering ICE in the streets, at home, in the jail, anywhere, is always to assert your right to remain silent. And in this instance, it should be a simple just checking of a form with the jailer saying that someone wants to decline the interview. And then finally, we have a lot of local counties that have taken the really strong step to say that they will no longer cooperate with ICE. So we have a longer list than this. I listed just a few of them, but Los Angeles actually no longer cooperates with ICE arrests, and that's huge. Los Angeles is actually the largest carceral system in the world. And so it was really significant for Los Angeles to take this step. Also in the Bay Area, San Mateo, Alameda, Contra Costa, San Francisco, Santa Clara, and several others have basically said that when people are leaving out of our jails, we will no longer voluntarily hand them over to ICE. So those have been excellent wins, and that's really a testament to a lot of the organizing that we've seen in those communities.
Hi, Grisel. We also have 2 questions in the chat that I wanted to flag. Someone's asking specifically about San Diego County, and also if can the criminal judge ask about an individual immigration status?
Those are great questions. So San Diego, unfortunately, at this moment does not have a sanctuary policy. However, I know that there are a lot of really strong advocates there trying to change that. But at this moment, San Diego does cooperate with ICE to the degree that they're able to under state law. And in terms of the second question, a judge also should not be asking about immigration status. Again, immigration status has nothing to do with any type of criminal offense in California, so it should be totally irrelevant. And I actually have to look this up, so I want to pause before going into this fully, but there also is a law in California around disclosure of immigration status in court proceedings, where there are actually some strong limitations around when immigration status can even be discussed in open court. So I'll just leave it at that. But I'm happy to send some additional materials on that law if you're interested. Those are great questions, so thank you. Okay, and so I've been talking about rights for quite a bit now, so let's actually dig into some of the most important rights that we have. So firstly, it's super important for people to know that everybody has rights under the US Constitution, regardless of immigration status. Whether you have a green card, whether you're a citizen, whether you're undocumented and you just got here, everybody has certain rights under the US Constitution. Okay, so one of the most important rights is the right to remain silent. So I'm sure people have heard about this and have seen it kind of play out in the criminal process on TV, where people are being arrested and they have their Miranda rights, and the cop says, "Oh, you have the right to remain silent," etc. So we have that same right in immigration proceedings. We have the right to remain silent. The challenging thing is that we don't have Miranda rights. In other words, aside from that state law that we have in California that I described, the Truth Act, aside from that, we don't, ICE agents ICE agents aren't required to inform someone of their right to remain silent. And I always think, what's the point of a right if you're not aware that you have it? And that's why we always put so much effort in these Know Your Rights presentations. That's why it's so important that you share with your community, your family members, that they have the right to remain silent, because if we are not aware of these rights, then we're not going to be able to enforce them. And they are so, so critical in certain cases, actually stopping an ICE arrest. So you have the right to remain silent. Whether or not ICE informs you of that right, you have it. And it's super important to never to assert your right to remain silent in front of ICE agents, especially around place of birth, citizenship status, manner of entry to the US. And again, without this, in certain cases, ICE may not have the basis to place you in removal proceedings. Some other bits of advice, you have, if the Fourth Amendment protects you, you have certain protections around, based on the Fourth Amendment when you're in your home. And so our advice there is that basically ICE cannot come into your home without either a judicial warrant or your consent. ICE almost never has judicial warrants. And so the last thing that they could potentially get is your consent. And so we always advise, never to provide your consent to ICE in entering your home. Don't even open the door a little bit to talk to them. Just keep that door shut. Because again, they pretty much never have judicial warrants, and it's not going to be in your best interest to allow them in your home. So keep that door shut. And then also never sign anything without speaking to a lawyer first. There are some forms that might be more benign, but again, it's hard to know when you're in the moment. So just don't sign anything without first speaking to an attorney.
Hey, Grisel.
And we know that, Oh, go ahead. Sorry.
Just a quick question. So I know when someone knocks at your door and they're like an authority figure, right? And you don't open the door. What if they do come in? Because we have heard of cases where people, come into your home.
That's a great question, Vero. So if they do come into your home without a warrant and when you haven't given your consent, our advice is still going to be to assert your right to remain silent, to still not say anything. But it still benefits you to have asserted your rights in that instance, because if ICE still comes in without your consent or without a warrant, if that person is placed in deportation proceedings, that person might actually have an additional way to fight their deportation case called a motion to suppress. So even if ICE violates the law in order to arrest you, because you asserted your rights, you actually might have an additional defense in deportation proceedings. So asserting our rights can both help us in avoiding an ICE arrest, and if ICE arrests us in violation of the law, it can give us an extra defense in deportation proceedings. So lots of benefits to asserting our rights. Thanks for that question, Vero. Okay, and because we know that it can be scary, to be quite frank, to assert our rights live in these moments, we also have these Know Your Rights cards. You can get them for free at the ILRC, and they basically lay out all of the rights that I just described. And I know that we're getting tight on time, so I'm going to move through these next slides a bit quickly so that I can pass it on to Vero, who's going to give us a great review of immigration relations. So we've heard that folks were also interested in know your rights in protest. And everyone has the right to uplift their voice and participate in civic engagement. We just want to ensure that people have all of the information that they need to decide what level of engagement is they would like to participate in, if that's something they'd like to do. Okay. So here, the big takeaway is really just that, I'm not sure if we're seeing ICE in the present protests currently. There have been viewings of ICE in prior protests. But if you do see this happen, to just let the ACLU know. We provided a contact there because they are tracking the issue. But to be honest, we haven't heard as much about ICE engaging in arrests at protests. The bigger concern is that someone at a protest could be arrested by local law enforcement, by the local sheriff or local cops, and that they could then be funneled into the criminal system and then be subject to the police-ICE collaboration that I described in previous slides. So that's really the biggest takeaway, is that our biggest concern really is that someone could potentially get a criminal arrest, and that could result in them being funneled through the jail to deportation system. Also quickly, who is at greater risk? So there are certain people who could be at greater risk if they in a protest. And I also want to be very clear, this is not to dissuade anybody from engaging in any of this activity. We believe strongly in everybody using their voice. We just want to give people the information to decide, to sort of measure risk and decide for themselves how they'd like to participate, if that's something they'd like to do. And so certain people who are going to be at greater risk, and this is in particular for people who might be in positions where they could be arrested. So for example, you're engaging in an action where you're going to be at greater risk of an arrest because of the role you're taking in that action. So certain people at greater risk are going to be people with prior orders, undocumented people, people with DACA, people on student visas, people who have pending removal cases, or people who maybe have lawful status, but there's a criminal offense in your history that can make you deportable when ICE doesn't know about it yet. For these individuals, what I would advise is talk to an immigration attorney so that you have a better sense of what the risk might be in your case, so that you can just be well informed prior to any participation. And if you do choose to protest, just know the risks, know your rights. There are a lot of really great guides out there on know your rights on protests generally that have a greater body of know your rights information that you should become familiar with. Have the name of an immigration attorney on hand, tell a trusted family member or friend about your plan, follow protest best practices. Again, ACLU and others have some great resources on participating in actions. And then always consult with an attorney just so that you know what the individual risks might be in your case. And with that, I will now pass it on to Vero, who's going to provide us a review of our immigration options.
Thank you, Grisel. Yeah. And, it's so important to know your rights and understand how you come in contact with immigration system, with ICE enforcement, right? That Grisel just went through. And, as part of that, know your rights, as part of that protection, it's also important to understand your immigration options or understand what's out there. As many of you who have been working with, immigrant communities or immigrants themselves, right? That there is unfortunately a lot of fraud in the immigration system, world where people give out information or people are told certain things that might not be entirely true, right? So one power of protecting yourself is understanding what's out there. And what makes someone, at least initially, right, could make someone initially eligible for something as you go and seek out more information. Next slide. So there are different forms of lawful status in the United States, right? And it's a really big, complex system with different types of status, different permanency, right? Different rights that comes with each of these, right? And this pyramid kind of shows you where they land, right? Grisel talked about, who could be deported and who's protected, right? And we learned that only U.S. citizens are essentially protected from deportation, right? Because when someone becomes a U.S. citizen, you're essentially out of this system, right? The system, this, cycle of, sending information to the US government or applying for a benefit or being asked to update any information in the system, right? You're out of that. Right below US citizens, right, we have green card holders. And most of the time when someone goes and seeks information about what options are available and what kind of benefits it could assess or access, right, your ultimate goal is to become a green card holder because from there you could become a US citizen, right? And, below that, there's other more temporary short-term benefits, right, like temporary visas or deferred action, as we see it through DACA, right, where people apply and have to reapply, right, because it's given for a short period of time. And with that, you have limited rights and limited access to status. Next slide. Right. And as I mentioned, right, when we're doing these screenings, the ultimate goal is to figure out whether you're eligible for a green card, at least in most cases, right? And a green card or lawful permanent residency, right, allows you to live, work, and travel in and out of the United States. It's permanent, as the name suggests, right? There are situations that could get someone into, a situation where they could be deported or removed. But for the most part, right, people are able to live and work and travel without issue, right? And once someone is a green card holder, right, their last additional step is to become a US citizen, right, which is highly encouraged to do because then that gets you out of this system, right, and it gives you the ability to, participate civically, right, vote, also protection if you want to go and move and live somewhere else. You'd never have to worry about informing anybody or coming back during a certain time, right? So there's that protection of it. Next slide. Right. And there are various ways within the immigration system that someone could get a green card, right? So not everything leads to a green card. For example, DACA, for those of you who are DACA recipients, know that it's something that you have to renew every 2 years, right? You're kind of like in the cycle of, you apply, you get approved, right? You have 2 years of work permit, you have 2 years of protection from deportation, and then you have to renew it again, right? Or for those of you who might have TPS, another form of temporary status, it's similar, right? You renew your TPS, right? You're in it in this cycle, and it's essentially the same thing over and over, right? And the idea, right, of getting or finding a way that you could get a green card is so that you could get out of that cycle, right? So there are multiple ways that this could happen, right? And it's important to screen to see if you would fit into any of those ways. The most common one we know is family-based, right? So someone who has status in your family who is able to petition you could then help you start this process to see if you could become a green card holder, right? Other ways that people could do this are through humanitarian forms of relief, which is a set of benefits for people who have been victims of a crime or have survived some sort of harm, right? That might make them eligible for a humanitarian form. Employment-based visa, right? In that process, right, that could give you either a temporary type of visa, or it could also open up the process for you to become a green card holder. In this case, your employer would be petitioning you instead of a family member, but it could also lead to you getting a green card. And then lastly, diversity visa lottery, right? Which is less known, right? It's only for certain people. But those are essentially the top ways that someone gets onto this path of getting a green card. Next slide. All right. And we could think about the road to lawful status as linear, right? So someone who is undocumented or doesn't have status is seeking an immigration benefit that will eventually lead to lawful permanent residency, right? Not everything does, like I mentioned. Some things only give you some sort of temporary protection, while others will give you eventually a green card hold. Make you a green card holder, which is what I'll go through today, right? And it's not going to be super detailed of each of the requirements of these benefits, right? There is going to be a need for, individuals to assess where they fit, and then to also assess how and when they could go and seek legal consultation, right? Because it's so important to go and speak to someone, because facts could determine whether you're eligible for something or not. Next slide. Okay, so what are the most common forms of relief? So we're going to start today by talking about family-based options. Next slide. So the family-based options, like I mentioned, is one of the most common forms that we hear, right? So you are married to a U.S. citizen, the U.S. citizen starts a petition for you, and you're able to get into this process to eventually become a green card holder yourself, right? Not every family member could petition you, right? There's only a set number of people or type of individuals, right, that could petition for you. And here we see the list of who could be petitioned by a U.S. citizen and who could be petitioned by a lawful permanent resident, right? And the groups are different, right? And we'll see that U.S. citizens are able to petition more people, right, than lawful permanent residents are, right? If you are a U.S. citizen, right, or you have a family member that is a U.S. citizen, right, U.S. citizens can petition their parents if they are over 21, right? So you have to be over 21 to petition your parent. U.S. citizens can petition their spouses, their children who are under 21 and unmarried, their siblings, and their sons, daughters who are over 21. And for sons and daughters who are over 21, I'm going to note that they could be married and unmarried. And I want to note that because as we go to the lawful permanent residents, we'll see that they could also petition their sons and daughters who are over 21. But in this case, it only could be if they are unmarried, right? And I want to make that distinction because we've seen cases where a lawful permanent resident is petitioning their son and daughter, and they've gotten married, and then they're no longer eligible for this status, right? Or to be petitioned to qualify under this process as the son and daughter of a lawful permanent resident. Lawful permanent residents have a smaller group of people that they could petition, right? They could petition their spouses, their children under 21 and unmarried, and then, like I mentioned, their sons and daughters over 21 and unmarried. And what the process would look like, the wait time, what requirements might bar you, or what requirements will be needed, will depend a lot on the type of petition that's being submitted, right? How you're being petitioned, right? Whether you're a parent, a spouse, a child, etc. The evidence that you will have to submit, right? First off is showing that you have that qualifying relationship, right? So showing that you are indeed married to the U.S. citizen, or you are indeed, the parent of a U.S. citizen, right? You will have to show the status of the person that's petitioning you, right? So if they are a U.S. citizen, right, do they have a birth certificate because they were born here? Or if they were naturalized, right, they applied for their own citizenship, right? Do you have that certificate of naturalization to submit with that? And that will be required to show that you meet that first, step of you have the family member who could petition you. And then from there, it could be determined what the wait time will be, if there's anything that you have to take into consideration, and then also what other evidence could be submitted. Next slide. So like I mentioned, right, the wait time will depend on many factors like the age, your marital status, the relationship to the petitioner, the country of origin, whether a visa is available or not, right? So US citizens who are able to petition their parents, their spouses, and their children who are under 21 and unmarried, those would be known as immediate relatives. So the wait time will be less than for individuals who are being petitioned by a lawful permanent resident, right, spouse, child, right? Those would be more in a preference category. So the wait might be longer, right? Because of when the visa becomes available, right? You need that first visa before you can move on to the next step of completing your process. Also, right, what's your age, right? If you're a child under 21, you have a US citizen parent, the process might move quicker because there's always a visa available versus if you're the son and daughter of a US citizen, you're over 21, and now you're thrown into this preference category, right? So you have to wait for that visa to become available. It also will depend on the country of origin. Some countries, if you look and speak to someone that could walk you through how visas become available, some countries have a very long wait time. For example, Mexico, if you're being petitioned by your US citizen sibling, I believe the wait time right now, we're looking at 20 years, right? From when that first petition is submitted to when you're actually able to move on to the second step of requesting your green card. So all of this is going to play a factor, and all of this information is important when you go and you speak to someone about your case or about the case of a relative, because all this will help, help you create a strategy, help you determine when to submit a petition, when to wait, or what, you could do to help something to move faster. Next slide. When you're doing a family-based process, it could be done in two different ways, right? So you could do an adjustment of status process, or you could do a consular process. For adjustment of status, those are for individuals who are able to complete the process within the United States. If you're ineligible to complete the process within the United States, then you have to do consular processing, right? And in order to become adjustment of status eligible, right, there's certain requirements that you have to show and meet. And the number one thing that usually makes people ineligible is that they came into the United States without status, right? So they enter unlawfully, they didn't enter on a visa. So therefore they can meet requirement 1 of adjustment of status, and then they have to consular process. Another thing we see that bars people from adjusting status is if they've worked without permission, right? So they work without lawful authorization, and there's something in this, process that bars someone from adjusting status if they've worked without authorization and they're being petitioned by someone that's not considered, or they're not considered immediate relatives, right? And the process gets a bit complicated, so I'm not going to go into all the different details. But here, it's important to note that if you're someone who did enter on a visa, or you're someone who maybe has traveled on advance parole, then you could potentially be adjustment of status eligible, and you should go talk to someone if you have that qualifying family relationship to see if you would be able to complete the process within the United States, because that's always more favorable than having to leave the country, right? So for consular processing, you have to complete the process outside the United States at a US consulate. And that could potentially create more delays, right? It could create, if issues happen abroad, it could mean that you have to stay abroad until that issue is resolved. So it's always better to see if you could be adjustment of status eligible. But those are the two processes that exist. Next slide. So then moving from family-based options, we also have humanitarian options. This is different benefits that exist under this category of what we've titled humanitarian options, right? They're usually benefits available to people who have been victims of certain crimes or survivors of certain crimes. And each of them have different requirements that individuals have to meet in order to be eligible. The first one, the Violence Against Women Act, or VAWA self-petitioning process, that one's really similar to the family-based process that I just reviewed, right? This one is a benefit. It's available to both men and women, right, who have been abused by a U.S. citizen or an LPR family member, right? And I want to say it's really similar to the family-based process because for VAWA, you have to show that you have that qualifying relationship that we reviewed, right? That you are the spouse, the child, the parent, right, of a U.S. citizen, or the spouse or child of an LPR, right? The only difference here, or one of the differences here, is that with VAWA, right, you could do it on your own, right? It's a self-petition, versus in the family-based process, you have to do it with the person that is petitioning you, right? It's more of like a collaboration, or with them, and without them, you can move forward. In VAWA, you could do it alone because there is this abuse that has happened, right? And it's, oftentimes abusers use someone's lack of immigration status as a way to manipulate or control someone, right? So the idea here is that you're able to move forward and obtain status without this person, right? But in order to be eligible, one of the requirements is A, that you could show that you've suffered abuse, and then B, that the person who abused you had status, right? Was a U.S. citizen or an LPR. For U non-immigrant visa, or a U visa as it's known in the community, this option is available to immigrant survivors of certain serious crimes who have been helpful or are helpful in an investigation. Here, the two key things to note is not every crime qualifies. There's a list of specific crimes that will qualify, and some of them being domestic violence, assault, stalking, right? And the second thing to note is that the U visa is dependent on someone getting certified that they were helpful, right? So usually you will need to have a police report, and you will need to ask this police department to certify that you were helpful in the investigation. And in California, right, this is as simple as making that report and not objecting or denying any questions that are reasonably asked to you by law enforcement, right? There's also T non-immigrant visas. Those are for immigrant survivors of trafficking. It could be labor trafficking or sexual commercial act, right? Trafficking in that sense. Next slide. We also have asylum. This is an option for individuals who have been harmed or fear harm in their home country. And the harm, unfortunately, it's not every harm, right? It has to be a harm that is, correlates to a protected ground. So you have to show that your harm is because of a protected ground, and it's quite complicated, right? But just to note from here is that asylum, that if you have a fear of your returning to your home country, or something happened in your home country, it's beneficial to go and speak to someone to see if that would rise, to a level of making you eligible for asylum, or what other information you would need. And the other one is special immigrant juvenile status. This one is for certain undocumented children and youth who have been abandoned, neglected, or abused by one or both parents, right? And for these last two, right, the harm, the abuse that could happen either abroad or here. And then for the first three that I named, that usually is for harm that happened within the United States. So just to note that. Next slide. And then other options, just to note, there are some temporary relief that could give you protection from deportation, as well as access to work authorization, right? So there's parole in place for military family. This is for individuals who have a family member that is in the U.S. Armed Forces. Individuals who request and are granted parole in place are able to get a work permit and protection from deportation for 1 year. It could also make them eligible for other benefits, possibly make them eligible for adjustment of status if they have the qualifying family relationship needed to start that process. There's temporary protected status. This is for individuals from certain countries that have been designated by the administration. It's not open to everyone. You have to be from one of the countries that have been designated, and you have to have been here when the TPS designation was announced for your typical country, right? So that's a lot more limited. And then the last two, I just want to note, right, as something that's there, there's keeping families together, parole in place. This is for spouses of U.S. citizens or stepchildren of U.S. citizens, right? This also gave people access to protection from deportation and a work authorization. I have a little star next to it because recently that was stopped by litigation, right? So while applications are still being accepted, people aren't being granted this type of parole in place. And if you're interested or think you qualify, it's important to speak to someone to see what are the risks and what are the benefits of applying for a program that's stopped by litigation, right? And then lastly, deferred action for childhood arrivals, or DACA. And that one is also stopped by litigation right now, right? But it's open for people who have DACA, right? So are able to renew. It's also allowing people to apply for advanced parole if they have a reason to travel outside of the United States as a temporary relief. And then just a note of relief for people who are in removal proceedings, right? I want to note that there are some things available to people who are in removal proceedings that might not be available to those who are not in removal proceedings. So it's always important to ask if you are in removal proceedings before an immigration judge, is there something that you could access or benefit from that doesn't exist, right? If you weren't in that case, right? Like cancellation or removal or BAWA cancellation. Next slide. Okay. So now that I've given you all this information of what immigration options are there, I always think it's important to start and tell people what could be out there, what could be a possibility, because then that could potentially inform you as you go in and get an immigration consultation, right? Which is the point of today's talk, right? Is what can you do when you go and speak to someone, and what kind of information do you need to provide to them in order for them to guide you and help you strategize on what you could do with your case. Next slide. So why get a legal consultation, right? It's important because immigration law is complex, right? Even as that we, work in it, talk about it, sometimes maybe even dream about it. It's complex, right? And we discuss it and we strategize about what it could mean, who it could access, what did the government mean when they wrote this, right? So it's complex. And oftentimes some people are told that, oh, it's just a form you have to fill out and let's answer the questions to the form and you're good to go. And that's not necessarily the case, right? Because every question on any form is related to a piece of the law that could make someone eligible or ineligible, right? So it's important to go and get a legal consultation and talk to someone about, your case, your facts, and what you could access. Even if you've met with someone, because I know a lot of people have talked to people in the past, it's always good to go and get another consultation or get a second opinion if you've already talked to someone, right? Things change, in your life, in the law, that potentially could make you eligible for something now that you might not have been eligible to in the past. So it's always good to go and just ask, right? Say that you married someone, right? Go ask if this changes your options, changes your the potential of you getting some sort of status, right? And even if you go and talk to an immigration attorney, it's always good to go and talk to someone else if things don't seem right, right? Sometimes maybe you're told something and you're like, oh, this appears to be too good to be true, or this appears to be too easy, right? So, it's okay to go and get a second opinion. It's okay to go and just, fact check what you've been told. If you just want to make sure that everything is, you've been told everything that's needed, right? So it's your right to go. You're not tied to the person that you talked to once, right? You're not even tied to the person who might have done a full screening of you. You could go and ask someone else. Next slide. When you're going for a screening, right, it's always a good idea to see if you need to make an appointment, right, to speak to a legal representative or an immigration attorney about, your eligibility, your family members, right, their status, your status, just to go and get information that's needed, right? In a screening, the purpose, right, or the goal is for you to get all your questions answered and also to, leave there with some sort of understanding of what your options are, what the benefits of those options are, and what risks there are of applying, right? Especially if you're someone who has never had contact with immigration, right? Maybe you're here, you've never had contact, you've never applied for anything, you've never had any, problems with immigration, etc. you want to make sure that you understand the risks and the benefits before you move forward. And you want to make sure that you understand if you're eligible for this, right? And what information you need to provide to show that you are in fact eligible for this, right? A screening is the opportunity for you to get all your immigration related questions answered. And if you are before someone that's hesitant about answering your questions, and I think that's a really a good flag for you to be like, oh, I need to go and talk to someone else, because someone should answer my questions and someone should help me understand what's happening here and what's going to happen in the future. Next slide. When you are preparing to speak to a legal representative, it's really important that you bring as much information as possible, right? So in order for I to make a determination of what you are eligible for, I need to understand your history, right? How did you enter? Who are your family members? Have you had something filed for you in the past? Have you ever had, an interaction with ICE? Have you been in immigration court? What's your employment situation? Have you had any incidents abroad? It's important for me to get this information because then I can make an informed analysis and determination based on your facts, looking at the law, and tell you whether you potentially could be eligible for something or maybe not.
Keto, I have a question. What if someone's missing some of this information? Do you have any advice for those folks?
Yeah, so for folks who might not have all of this, you could go with what you have now, right? So make an appointment, talk to someone, tell them what you have an idea of, right? So maybe you entered when you were really young and you think you entered around 1990, but you're not exactly sure, right? That's a way to go about it. And then the legal representative could help you understand what other information you might need to gather. The other way is talk to your family members, right? Because our family also knows about our history and knows about, what might have been filed or how you entered or whether you exited one summer to go spend it with your grandma, right? Especially if you're younger. So it's a good opportunity to have a conversation with your family around what exists in your own immigration history. And then lastly, right, if you are unsure about contact with law enforcement or whether you were in immigration court or whether you have contact with ICE, you could also request records, right? So if you go to an attorney and you tell him, I think that, in 2015, I was stopped by the police, right? But I'm not sure what happened. I know it happened in Fresno County. What do I do, right? Then we could guide you in where you could go request those records. And if you think you potentially had an old petition, but you're not entirely sure, we could also request records from immigration. And once we have that information, read it, review it, and then assess what you could have access to. Next slide. Okay. And the most important thing, right? Yes, share your information, but it's also to ask questions, right? And it's so hard, for me at least. I know when I go into a situation and someone says, so do you have any questions? I'm like, do I? So it's always good to prepare ahead of time, right? And have a list of questions you want answered. So when you get that opportunity and they ask you, do you have any other questions? You're ready to go, right? Because for, hard situations, sometimes it's hard for me to think of my feet. So I like to have things written and be ready to go, right? So when you're before them, right, most important thing is to understand what you qualify for, right? So ask them, based on what I told you, what do you think I qualify for? And they might need to gather more information, right? And if they are looking out at the whole picture, they might ask you to bring more information, right? But it's good to ask, what do you think I qualify from? And then as you're going through this discussion with your legal representative, it's also important to understand what you want to get out of what you're seeking and what's important to you, so that you let them know, right? Because that also helps in the strategy and assessment of what you want to apply for. If you're eligible for multiple things, right? So some forms of immigration relief allow you to ask for family members or include family members in the process. Some might not, right? And if that's important, ask them, can I include family members in this, right? And then some forms of immigration relief might allow you to travel back to your home country. Some might not. And if that's something that's important to you, ask them, right? Is this going to prevent me from going back to my home country? In addition to that, right, some things will make you ineligible, like having traveled maybe outside of the United States after having entered and doing that several times. So it's important to ask them and tell them, you know, does it matter that I have traveled outside the country multiple times? Does it matter that I came without a visa? And then also, this is the opportunity to understand what they're going to charge you, because while there's a lot of available free services and, there's free services on your campuses, maybe that's not always the case with who you go and what type of case they are taking. So ask them, what is the cost of the service? What is included? Does this presentation include any court dates, right? So what happens if your case is referred to court, right? Ask them if whether they'll represent you then as well. And then also generally just ask them about the process, right? A lot of times it's confusing how long a process might take, or whether, there will be delays, or what kind of benefit you will be able to access while you're waiting. So this is your opportunity to ask them all that and to get all these questions answered. Next slide. And then watch out for fraud, right? So there's a lot of fraud. We started talking about fraud, right, in this that exists. A lot of times people promise more than they could actually deliver. And a lot of people fall victim to fraud, right? So it's important to seek information and seek help from someone that's trustworthy, right? As part of the system, you all have access to legal services. You have access to find information and legal services on your campuses. I would suggest that you start there, because the service provider will be someone that's trustworthy. And then just note that here, only an immigration attorney or an accredited representative can give you legal advice. And when you go before them, this legal service provider should always provide you a contract that tells you what services they are providing you, where they're representing you, what you're applying for. And if you have to pay them, they should give you a receipt for those payments and the services that payment covers. They should explain the process and the answers to any of your questions, right? And they should follow the rules set forth, right? And if anything seems off, it's your right to go and speak to someone else, even if you started with an attorney, right? It's always your right to go and speak to someone else to check that the information you were given is correct. Next slide. And then, there will be situations where maybe right now you don't have an option, right? So even if there's not an option now, it's important to go and continue to get legal consultations on a regular basis, just in case anything changes or anything opens up. And then also, almost every form of immigration relief will require you to offer some sort of evidence in your case, right? Whether it's family relationships, whether it's presence in the United States. It will require you to say that you haven't had contact with the criminal system, or if you have, then what that looked like, right? To see whether it makes you ineligible. So as of now, if you don't have an option, it's always a good idea to start collecting evidence of presence in the United States, or if you have family relationships, right? Making sure that you have that documentation to show what family relationship you have, or if there are any old petitions, right? Maybe your mom was petitioned by their brother and she has that receipt. Maybe make a copy so you could have it also in your records, because you never know what that might open up in the future. And then ultimately stay informed of any changes and updates, right? Because things change and things move all the time. So definitely stay informed. These webinars and this service is a great way to stay informed, right? Because, the information that's being given is trustworthy from an organization that's trustworthy. Next slide. All right. So I will leave it there and see if there's any questions we might want to answer out loud.
Mia, did you see any questions that would be helpful to sort of share out verbally with the entire group?
I do see any. I've been trying to answer all of your questions, but if someone wants to come off mute and ask a question, we're happy to help.
And Cynthia, we're happy to stay on for the duration to answer any questions either verbally or via the chat.
So I enabled the chat if there are attendees that want to ask some questions. I have one person raising their hand, Dr. Lisa Lim. I'll allow her to. Oh, I think I lost.
Hello, can you hear me?
Yes.
Oh, okay. A couple questions. One, I'm a psychologist at Cal State San Marcos, and I specialize in serving students who are undocumented and mixed status. And my questions are related to that. So one of my students just received a U visa and was wondering if that provides protection so that she can access the California Cal VCP benefits or Medi-Cal, CalFresh, or should we not access those to keep her kind of protected and hidden and safe?
That's a great question. There's a lot of questions about benefits, right? And which benefits could be accessed if you have different statuses and where that falls. And we know that in the past, there has been a lot of fear around public charge, right? Public charge became very prominent in mainstream media. The question is, has this person been granted their U visa already, or do they have it pending? Do you know?
She showed me a letter that said like this is proof that you have the U visa and here's the expiration date, but it's just a letter.
Okay. So I wanted to note that because for a U visa recipient or someone that's requesting a U visa, there's two different points where they could access benefit, right? So this individual that's been granted a U visa or people who have been granted U visas, they don't have to worry, right? They could go and access any benefit that they're eligible for, and it should be fine. It's important to talk to someone who understands all the requirements of the benefits, right? To make sure that they're only accessing things that they actually qualify for here in California, right? And then also to note, U visa applicants, right? So people who are requesting a U visa, once they get a receipt notice, right, that says we have received your U visa application and we are in the process of reviewing it, right? Those people are also eligible to access public benefits here in California with their receipt notice, right? So there's two different points, and they shouldn't worry about getting in trouble so long as they qualify for the benefit, right? So it's important to go and speak to someone who could understand or who understands, right, what those benefit requirements are. But their U visa receipt and their grant of a U visa gets them access to those.
Awesome, thank you. And I already forgot my next question. I apologize.
Hello. Question from Dora.
Oh, hi.
Hi, Dora. We can hear you.
Good afternoon, everyone. Okay, I have a question. Like in 2002, my uncle made a petition for my dad, who is his brother. But 5 years ago, my uncle died. What can my dad, if he can continue with, the process, or what we can do in this case?
Yeah, no, it was the way she put it in her mouth. She was like, oh. She debated, and she's like, should I hold it? I'm like, I see a whole bunch of rice from.
So for that case, the best thing you could do is make a legal consultation. I know it's such a generic answer and it doesn't answer your question, but it would be important for someone to look at the receipt notice you have or any documentation you have of that petition. And then they would be able to guide your dad to see if there's anything else that could happen in his case, or guide you or anybody else from your family who might benefit from that petition. There was just some information put in the chat around where you could find someone to speak to. Just, because like I mentioned, immigration is very fact dependent on the individual. So we want to make sure that whatever you get, right, whatever type of petition that was, that you get a full information on what next steps you could take.
And then we do have one or two questions in the Q&A. I can read the first one. Can more details be provided for spouse petition for adjustment of status, the form, and cost?
Hi, so I was about to answer that one, but typically, and I'm assuming you're saying for spouse petition as a U.S. citizen spouse. If that's the case, I mean, there's the process, the form you mentioned, it's typically the I-130, and then if the person can adjust within the United States, you can file that concurrently with what's called the Form I-485. The costs of those forms sometimes change with USCIS, sometimes changes their cost. So I would definitely go to their website to learn more information about their filing fees on that. But typically, from what I saw from the question, you wanted information of just the form and the cost. So hopefully that answers a bit of that question. And as Veronica said, always best to consult with an immigration attorney to understand better the process and the fees associated with those applications.
And folks, we're just hanging out for any other questions. So feel free to drop them or unmute yourself or raise your hand. And we'll just hang out until 1:30 for any other questions.
So,
I see that Dora has their hand raised. I'll also stop share so y'all can see our faces too.
Oh, okay. One more question. Okay, then. Okay, my daughter has DACA, right? And now he's in a process to get the visa U visa permit to work. are you recommend that she keeps renewing her data as well, even though she has the U visa permit to work?
755 or 697.
Yeah, that's a really good question because we've seen that come up a lot where we have DACA recipients who are eligible for a U visa and have been given that first check, right? Where they're given that work permit based on that first check, that they seem to be potentially eligible for a U and they're given, some sort of protection. In those cases, because of how DACA is right now in the courts, right? Because of the benefits that DACA could give you that maybe a U deferred action work permit doesn't give you. It's beneficial for the DACA recipient to continue to renew in case that later on something might happen with the U, right? Usually that first work permit that's given is under what USCIS calls bona fide determination, right? Which is the first review of you being eligible for a U visa. And later on, once a U visa becomes available, they're going to do a final review where they will give you a final answer as to yes, you're granted or no, you're granted, right? So because it's not a final, and if someone's eligible and could continue to pay for a DACA work permit or for DACA, it could be advisable for them to continue renewing their DACA, especially because of how it is right now in the court, right? That only people who have DACA could renew, right? And that could change in the future, right? So we want to continue having access to that. I don't know if Mio or Grisel have other thoughts around this.
Okay, following that question now, if my daughter has continue renewing the DACA and has the U visa permit to work now, is that okay? It is a possibility that she can apply for advanced parole, or because she has these two, it is not recommended.
Not over them.
Yeah, so for her, if she is ready to see if she could be eligible to apply for advanced parole, I would recommend she makes an appointment and speaks to a legal representative about her case, the facts of her case. Just generally, right? If you have U deferred action, right? So the first work permit for you for a U visa, and you have DACA and you have a reason that you qualify to travel under DACA, it shouldn't be a problem for you to travel. It should not mess with you, your U visa deferred action work permit. But in the individual case, it's important to go and speak to someone about why you want to travel, how you could access advanced parole under DACA, and just to make sure that everything looks good for you to go and travel, right? Because you are leaving the country, you want to make sure that everything is good, that there are no red flags or any things of concern, right? But just generally speaking, you could access it, you could travel, even if you have these two forms of deferred action.
We have time for one last question if anyone has one.
There was a question in the chat around whether a green card holder could petition their spouse. Was that answered? Maybe it was answered already.
Oh, yeah, I did.
Awesome.
I did respond, but if the person has a follow-up on that, the answer is yes, but given to the immigration history, it could be the nuances of adjusting status could affect the spouse on non-citizen spouse. But yeah.
Oh, go ahead, Crystal.
Okay. Oh, no, I was just going to say thank you to everybody.
Well, thank you everyone
Jen.
for attending. If you would like to book a free consultation, go ahead and visit the Find Your Ally website, and you can go ahead and book from there. But thank you to our partners at ILRC for the presentation. Thank you, everyone.